Hi, my name is Paul Wake. I'm going to talk to you a little bit about juvenile defense work. First, I need to point out that juvenile court deals with two general areas: delinquency and child welfare. Delinquency cases involve children who are accused of committing crimes. Child welfare cases involve allegations that a child is dependent or neglected or abused. This video deals just with delinquency. To defend a child in juvenile court, you need to understand three things. First, why and how some cases are resolved informally and non-judicially. Second, why and how some cases are resolved judicially. And third, why and how some children are sent to adult court to be tried as an adult. We'll talk about each of those three things in turn. Juvenile court is about fixing kids. In keeping with that focus, many charges are resolved informally and children never see a prosecutor or a judge. Early in the process, a child and a parent may meet at a preliminary inquiry, or PI, with the probation officer assigned to intake. The probation officer will collect some social information, looking into the child's educational situation and home life, and if the child doesn't have a serious presenting offense and doesn't have much of a history, may suggest a non-judicial resolution. That sort of agreement could involve payment of a fine, doing some community service, or perhaps taking an appropriate class, such as a tobacco cessation class or an anger management class. If a child completes that agreement, this charge wouldn't count as a record against the child, although certainly the court would have a computer entry that this had occurred. Because non-judicial resolution is relatively unobtrusive and doesn't technically count as a record, the best service you may be able to offer a client is no service at all. If it appears that it would be appropriate to get a non-judicial resolution, you could simply counsel the client to go in and do that. You can certainly appear at the PI as an attorney. Be aware, though, that if you begin to argue the charge, the PO will probably consider that a denial and set the charge for pretrial later on so that you can plea bargain with the prosecutor. Cases that aren't handled non-judicially will be handled judicially. That process involves arraignment, pretrial, and trial. There are some local variations, such as waiver of arraignment or combining arraignment and pretrial. You need to look into how things are done in your particular county. The bread and butter of this process, though, will be pretrial. That's where you do your plea bargaining with the prosecutor. Now, some of these children will have been put in detention at the time of arrest. Those children are entitled to a detention hearing within 2 working days, and at that hearing, bail is not an option. The judge will simply decide whether to hold them or release them. The presumption is that they should be released unless there'll be a threat or a flight risk. It's possible that they may be released to a detention alternative program such as home detention or some sort of day reporting system. If you're hired in time to go to the detention hearing, you should simply appear and make an appropriate argument with regard to whether they are a threat or a flight risk, and the judge will make an appropriate decision. More commonly, you'll be hired in time for pretrial. Pretrial is the bread and butter of defense work. It's where plea bargaining takes place. To prepare for pretrial, you should have made an entry of appearance and made a request for discovery. Once you get that discovery, it should consist of the police report, ideally of the petition, which is the charging document, and the case history, which is the juvenile's rap sheet, and if it's been prepared yet, the dispositional recommendation that the probation officer assigned to the case will be given to the judge. With that material, and with your client interview in mind, you can go to pretrial and discuss a good plea agreement with the prosecutor. Next stage will be pretrial, at which you'll plea bargain with the prosecutor. But I should make this point, which may not be really apparent at first. Unlike in the adult system, the prosecutor is not usually involved in the case from the beginning. In fact, the prosecutor has a narrower role in juvenile court. It's the probation officer assigned to the case who does intake processing, and the probation officer who will make the recommendation to the judge at disposition. You need to not assume the prosecutor is the only important person in the process. The probation officer assigned to the case, or occasionally some other case manager, is also an important party, and you need to talk to them and make sure they understand where you're coming from and see where they're coming from. Now, new attorneys are sometimes handicapped because they're not sure what sort of options there are available in terms of plea bargaining, in terms of disposition of a case. It would be very helpful to you if you could find a local mentor, since the things that may happen to a child vary depending on the services in your county, and ask that person what sort of dispositions are available in that area, and also what sort of plea agreements are typically worked out. That way you'll have a better feel for whether what the prosecutor is offering is fair, and you'll have a better ability to make a counterproposal that may be more appropriate to the child. Another resource is the misnamed Juvenile Sentencing Guidelines, available online, which allow you to assess the general sorts of sanctions that may be imposed on a child. The nutshell view of what may happen to a child in juvenile court is pretty much dependent on what the child has done and what the child's history is. If the child doesn't have much of a history and hasn't done anything terribly serious, there could be sanctions such as fines or community service or classes, much like what you would get if you'd been resolved non-judicially. After that, a child may be put on probation, which means a probation officer who has a supervision caseload will be assigned to occasionally check on that child's school attendance, maybe their drug use and so forth, and see if they're following court orders. State supervision is the next step up this ladder of graduated sanctions, and it's basically intense probation, which is going to involve daily contact. After that, juvenile justice services may become involved. JJS used to be called youth corrections, and that's pretty much what it is. If a judge puts someone in a community placement, they may be put in something like a Proctor home or a wilderness program. The end of the line is JJS secure confinement, which is basically juvenile prison, and that can extend until the child is 21. Anywhere along this ladder of graduated sanctions, there could be a detention stay of up to 30 days. There could be placement in the O&A facility. Observation and assessment does psychological testing to try to get a handle on what a child's problems and needs are. There could be placement in the Genesis facility, which is at the point of the mountain, and people are put there in order to work off the restitution, and various other sanctions. One children are usually aware of and don't like is the driver's license suspension that accompanies first drug charges or second alcohol charges. Many children who commit Class A misdemeanors or felonies will have to give a DNA sample for the DNA database. Some attorneys are concerned that children accused of sex offenses will have to register as sex offenders. As of 2008, that's still not required. The legislature has wisely resisted the Adam Walsh Act's requirement at the federal level that states register children as sex offenders. Keep an eye on that, though. It's possible that will change in the future. If at pretrial you can't resolve the case, you'll head for trial. The trial will be much like what you'd expect from justice court or district court, except there won't be a jury and there probably won't be spectators. The important thing about trial is simply to prepare. If you prepare, you may win, and even if you don't, you'll look much better than most of the attorneys the judge sees. One thing to keep in mind is expungement. After you've finished the case, before your client goes on his or her way, be sure to suggest to the client that after they turn 18 and after it's been a year since their last involvement with the juvenile court, they go up to juvenile court, get an expungement packet, and apply for expungement to clear the record. You can help with that process if you want, although it's generally something that kids can handle on their own. Some cases are so serious that the prosecutor will try to have the child transferred to the adult system to be tried as an adult in district court. In Utah, there are 3 ways that can happen. One is direct file. Children who are 16 or 17 and murder someone or commit a felony after having been in secure confinement will be filed on by information directly in district court, and they won't go to juvenile court as any part of that process. The next way is the serious youth offender process that applies to 16 and 17-year-olds who are accused of mainly aggravated felonies. If a child commits one of those 10 qualifying offenses, they'll be filed on by information in juvenile court, there'll be an initial appearance, and then there'll be a preliminary hearing. At the preliminary hearing, the prosecutor only has to show probable cause that the crime was committed and that the minor committed it. If the prosecutor can show that, then unless you can show that all of 3 mitigating factors apply to the child will be transferred. One of those factors is that the crime was not violent or aggressive or premeditated. Since most aggravated offenses are, it's difficult to make that showing. It's difficult to prevent transfer under the Serious Youth Offender Act. It might be good if you have one of those cases to talk to the prosecutor early and see if there's any way to talk the prosecutor into keeping the child in the juvenile system, perhaps by working out some sort of agreement in advance as to what an appropriate placement would be in the juvenile system. The third way to send someone to the adult system is certification process. In this procedure, the prosecutor files a motion to certify and an information against anyone 14 or older who's committed any felony the prosecutor thinks should be transferred. There are some statutory criteria the judge considers, but it's basically a judgment call in which the judge looks at the facts and a report prepared by juvenile probation and decides whether the child can be rehabilitated or should be abandoned to the adult system. And frankly, that's the attitude many juvenile judges bring to it. Therefore, you have much better chance of keeping a child in the juvenile system in a certification process because you mainly only need to prove to the judge that the child can be rehabilitated in the juvenile system. Now, because these adult transfer cases have much higher stakes than other juvenile court cases, it's important to be on your toes and fully prepared for them. You need to understand what's going on. It's not possible in this video to go into a great deal of detail in how to handle those cases. A good resource on juvenile defense generally, and one that has some details on these cases, is the How to Manipulate Juvenile Prosecutors website. I look at that website either if you have an adult transfer case or just as a general resource on juvenile court in general. Juvenile court practice is enjoyable because you not only get to defend a child, but you get to help that child grow. However, you need to understand how juvenile court works before you appear. It's important not to just waltz in and assume that because you've been in justice court or district court, you understand how juvenile court works. So be sure to read the Juvenile Court Act, Title 78A, Chapter 6, and also read the Juvenile Court Rules, and look at some of the other resources mentioned in this video. Then, go to detention hearing ready to make a good argument about release. Go to pretrial having an idea of what sort of plea agreement would be appropriate. Have your client go to an expungement hearing eventually. Go and do some good. Thanks for watching this video.